We are live. So good evening, everyone. This is the second in a series of four workshops on special needs planning. I'm Gordon Holmes, and I want to thank everyone for joining in for this evening's workshop. This evening, it's on guardianship and alternatives and also ABLE accounts. So again, thanks very much, everyone, for being with us. Like last week, if you have a question, we'll ask that you unmute as opposed to using a chat. So just unmute and ask the question. And we'll have a few minutes at the end, but not a lot of time. So if you want to ask the question during the presentation, that's all right. Simply unmute, ask the question, and then after that, if you could remute to keep the background noises down, I would appreciate it. Again, I'm Gordon Holmes. I'm a certified financial planner. My practice focuses almost exclusively on special needs planning. And I have office in Indianapolis, Louisville, and Lexington, Kentucky. My team and I, it's special care. We serve families throughout the entire state of Indiana and most of Kentucky. You'll see a few references to Kentucky, but by far, the majority of the information, of course, is focused on Indiana this evening. In addition, as far as my team is concerned, my relationship coordinator and parent advocate is Jamie Sturchie. And Jamie is the one that's coordinating the free follow-up consultations that we promise all participants. So again, as a result of being a part of the presentation this evening, we're pleased to extend to you a free follow-up consultation that can be in person or it can be virtual, like Zoom, like we're doing this evening. The way to do that would be simply to respond to one of the pre or post emails that you receive, pre or post workshop emails. So you should have received an email, I think Tuesday, it went out for today, and then there'll be an email following the workshop. Any of those emails are being sent, I believe, by Jamie, and so just simply hit reply and indicate you're interested in scheduling your free follow-up consultation. We set aside up to 90 minutes for each family, and there's absolutely no cost in scheduling that. Okay, well, with that in mind, we're going to plunge ahead with the PowerPoint presentations. And so I'm going to go to screen share. And up first is guardianship. Okay, and if someone would like to, let's see here. All right, there we go. If someone wants to give me a nod or an air pull just to make sure that the slides are showing on the screen, that would be okay. Thank you very much. Appreciate that. Again, first up this evening is guardianship. Again, I remind you, if you do want to ask a question, then simply unmute, ask the question, and then remute. So there we go. Disclosures, we're not all things to all people, but we sure work hard to support and help the families that we work with and the special needs community. This evening, the agenda on guardianship is going to include what it is, terms to know, state laws, types of guardianship, appointing a guardian, liability of a guardian, removal and termination of a guardian, and alternatives to guardianship. Okay, and this is only the first half of this evening, so a lot to cover. So what is guardianship? Guardianship is a legal relationship between a capable adult, the guardian, and a ward, otherwise known as the protected person, the person for whom guardianship is or was obtained. In most states, the law presumes that individuals over age 18, otherwise known as the age of majority, are able to make their own decisions and know what's best for them in their daily lives. Some may feel it necessary to apply for guardianship to protect their loved one who has special needs. Terms to know: protected person, the individual for whom guardianship is sought. Petitioner is the person who files the forms to request a hearing, the subject of the hearing, of course, being guardianship. Frequently, it's a parent, grandparent, or it can be other party. Respondent is the person for whom guardianship is sought, meaning the person that will respond to the petition for their guardianship. Guardian or conservator, the person appointed by the court to handle the protected person's affairs. The limited guardian is a guardian with fewer than all powers and duties of a guardian. So a limited guardian may be guardian over certain aspects of the individual or their lives as opposed to everything. The guardian is the person responsible for the care, custody, and control of the individual, as well as their financial resources. Conservator is financial resource only. A guardian can be a person or an entity, and there are also professional guardians. Trustee is a person given powers of administration of property held in a trust with the legal obligation to administer the trust according to the trust document. So a lot of terms involved. Guardianship does vary by state. Guardianship depends upon state laws. It's not the same everywhere. That's the reason that when one moves out of state, the guardianship really should be transferred to the new residence state. And that would be being held by the state of residence of the individual for whom guardianship is obtained or being sought. You want to seek legal counsel, local legal counsel, to get state-specific information. It doesn't matter where in the state the attorney is, but attorneys are, of course, are licensed to practice in certain states. So if you're seeking guardianship for someone in Indiana, then you want an attorney licensed in the state of Indiana. This becomes an issue sometimes when we're at the state line, such as if we're working with a family from New Albany, but an attorney is in Louisville. So Louisville is obviously is the metro area that includes New Albany, but is the attorney in Louisville licensed in Indiana? So those kinds of issues at all the borders. You've got Evansville and Henderson or Owensboro, Kentucky, and you've got, of course, Lawrenceburg and Cincinnati and so forth and so on. An example of what's specific to a state is prior to 2018, Kentucky was the only state to require a jury trial when making a determination in a guardianship proceeding. So having an office in Louisville and Lexington, I'm very familiar with this. And prior to changes made by state statute in 2018, when a parent sought guardianship for their 18, 19, 20-year-old, this type of thing, then they not only filed a petition, but at the time of the court hearing, a guardianship of their peers would be impaneled to hear the guardianship proceedings. And it could be rather unnerving, so to speak, airing your family laundry in front of a group of your peers. So fortunately, in 2018, they got caught up to date, and as long as the guardianship is not contested, then they have dispensed with the jury trial. However, when guardianship is contested, in other words, everyone's not on the same page, in Kentucky, they can still impanel a jury. So you might be curious as to when guardianships are contested, and I would say probably the most common is when we have estranged parents, that is parents that are divorced or perhaps they were never married. And one of the parents is pursuing guardianship for the minor turning age 18, and the other parent wants to be a co-guardian, or perhaps thinks that guardianship is unnecessary or inappropriate for their son or their daughter. And so when there's not agreement, then you have a situation where the attorneys and the judge and so forth all review the material, and guardian ad litems can be appointed to evaluate the situation and to attempt to advise the court relative to what is in the best interest of the individual with special needs. So that's an example of where things can be contested and can get more challenging, shall we say. Most of the time it's not contested, and either two parents are going in to get joint guardianship or a single parent's going in. But do know that if one parent is going in and the other parent is still living or has parental rights, there is a notification process. Therefore, the process is set up in such a way that one parent could not obtain guardianship without the other parent's awareness. So just some situations to review with you there. Okay, as far as types of guardianship are concerned, full guardianship is listed on the left, and full guardianship is guardianship over both the person and their estate or their finances. So it's complete guardianship. In the center, you have limited guardianship, and this again divides down typically into person versus estate. So at age 18, if a parent or parents are seeking guardianship and the the minor turning 18 has no estate, that is, has no assets, then most often guardianship would be limited to the estate. If the individual that guardianship is being sought for has assets such as savings, checking, investments, or property, etc., then it may be more appropriate to secure full guardianship if that is the intent. Joint guardianship on the right speaks to where there's more than one guardian. We see guardianship granted typically to an individual or to two individuals. I don't recall seeing guardianship granted to three. It starts to become rather challenging to keep track of who's responsible for what, and you can kind of get into the finger pointing. And usually the courts are not too quick to warm up to having guardianship by committee where nobody's really responsible, and therefore how does the court hold them responsible? And it's kind of ripe for he said, she said, and so forth and so on. So usually between two individuals, those individuals do not have to both be parents. We do see joint guardians between a parent and adult sibling of the child with special needs. So that's where a parent who perhaps is in their 50s or 60s goes to court and becomes a joint guardian with maybe a 20-some-odd-year-old adult sibling of the child with special needs. Also, in the event a parent passes away, and I had a Zoom meeting with a family in such a situation where in the last couple of years, the father has passed, then the remaining parent can go to court to become a joint guardian, again, with some other family member. If they do this, this would kind of preemptively set up who would be the successor guardian in the event the remaining parent dies. So sometimes there's value in kind of stacking the deck in advance so that whoever is left as a guardian doesn't have to go to court, but if they're already a co-guardian, they're in the queue and the court has already blessed their involvement. Questions on types of guardianship before we move on? Okay, in the state of Indiana, once guardianship is obtained, generally, the county court can require reporting. And I say can require reporting because not all counties do. And so it varies by county. And so if you're going to pursue guardianship in your respective county, you can certainly call the county courthouse or call the family court and inquire as to what, if any, reporting that they are enforcing in your respective county. Where the court is asking for reporting, it's a general reporting of the whereabouts, the physical health, financial health, and the status of the individual. This does two things. Number one, it confirms that the guardian is very much in touch with what's going on with the ward or protected person. And then second of all, it helps to alleviate any liability concerns on the court's part as to whether the guardianship they granted to begin with is continuing to function appropriately, et cetera. Now, in the state of Indiana, typically that reporting is at the first anniversary of the guardianship that's granted. So if the judge signed the order July of 2021, then the first report, if the county court is enforcing the requirement to report, they would typically want the first report July of 2022, and then thereafter every 2 years. So guardianship in 21, first report 22, and then 24, 26, 28, et cetera. And that would be as long as the guardianship is active in the state of Indiana. As we will see later, guardianships can terminate in one state and get started in a different state, and that transfers the reporting requirement based on the laws of the state where the guardianship is transferred to. Okay. The process. We won't go through all of this. Suffice to say, it's the government, and of course there are forms. So there's processing fees. In the state of Indiana, there's a lump sum fee of approximately $180 that goes in. And then there's petition, doctor's report, and various forms that are a part of the petition process. So this is where it's helpful to work with an attorney that has expertise in guardianship. So that way you know that I's are dotted and T's are crossed. You don't get to court and you're ill prepared. You don't get to court and find surprisingly there's some contested situation, et cetera. Again, generally with guardianship, it's best to have legal counsel. Now, if there's not sufficient resources to afford legal counsel, There are low-income clinics, such as the Northside Christian Legal Clinic. There's Disability Legal Services of Indiana, which is a nonprofit that we at Special Care do help sponsor and fund. And then there's also Legal Services Indiana. And then there's also the Bar Association. There's also the McKinney School for Law School, which is one of the two law schools for the University or Indiana University, and they run a legal clinic. And so, believe me, there are options available to get assistance with guardianship where it's documented that resources are very limited. Where guardianship is the appropriate direction to go, it can be done basically regardless of the financial circumstances. So keep that in mind. In addition to that, attorneys that are in our informal network, and again, there are about a dozen attorneys between Indiana and Kentucky in our informal network. And we do have attorneys in Fort Wayne, Lafayette in our network, Indianapolis, New Albany, Evansville, Louisville, and so forth. So we have the geography covered. And most of the attorneys we work with are amenable to a payment plan so that the fee can be stretched out over 6 months or perhaps as much as 12 months. Now, what is particularly handy as it relates to guardianship when appropriate is that usually in tandem with applying for guardianship, parents would be applying for SSI. And that's because if you have a child or dependent where guardianship is appropriate, that's an indication that they lack capacity for a guardianship alternative, and lacking capacity certainly would be an indicator that we would want to be considering an application for SSI. Well, last week we talked about government benefits, including SSI, and it was a great evening. It was recorded, by the way, and I believe it's my understanding it's being posted under the DSI website. And so if you participated in last week's workshop and want to revisit part or all of it on government benefits, and boy, we really went into it with everything from employment and SSI to the student earned income exemption and adult child benefits and so forth. So if you want to revisit some of that, because it was a lot of information, then do go to the DSI website and look under blogs and presentations, that type of thing. And my understanding last week has already been posted. And this evening's presentation should be posted, if not by tomorrow, by early next week. And, and check that out. Also, please bring it to the attention of others in the special needs community, so that they can take advantage of this as well. But as far as the guardianship process, again, you're applying for SSI typically at the same time, and getting approval for SSI typically brings in as much as close to $800 per month tax-free to assist with food and shelter expense. That goes to the parent if the then 18-year-old is living with the parents, and that helps the parents with food and shelter expense, etc. And usually that helps with the budget, and it becomes much more affordable to afford the monthly payment to the attorney for their services to assist with guardianship. So all of the stuff that kind of occurs close to or around the turning of age 18 works together well to get through the process. As you can see, guardianship process continued. The court will appoint an attorney for the respondent, that is the person that you're seeking guardianship for. Not in all counties, this really varies. That person is called a guardian ad litem. That would be the case in Marion County. The more we get out into the hitherlands, the less of this is done, and it's a bit more casual or informal. These days, of course, most of these hearings are being handled virtually anyway. The court will schedule a hearing date. It's within 60 days. Usually it's within weeks. So again, depending upon where you're at, you may get a hearing in as little as 2 or 3 weeks, or in more metropolitan areas, you may find it's closer to a month or 5 weeks. The court will appoint a team where appropriate, basically to confirm the disability, make recommendation to the judge, this type of thing. So there's a process to go through. It's very rare to go to court for guardianship and not come out with guardianship. Usually you're in and out of the court, the county offices within an hour. It usually does not take that long. Your child with special needs does need to attend the guardianship hearing unless there is a perfunctory of evidence why it is harmful to them or why they are unable to participate. But generally they do need to be on hand at the time the guardianship is granted. Generally, the attorney that you're working with will meet with you before the hearing. And in fact, all this being virtual and so forth, meetings are much easier to handle these days. But the attorney will not only want to meet you as parents, but typically will want to meet the child, since the child will be a part of the proceedings. And if the son or daughter is aware of what's going on and how it's going to play out and the various steps, then usually there's less anxiety and things move a bit more smoothly. So appointing a guardian requires proof to the court that the person is not able to care for himself or herself. That is, they lack capacity, and that's why someone needs to manage their affairs. A physician certificate is required in Indiana as a part of the guardianship petition. Most often that is the pediatrician. It can be a specialist, but it has to be an MD, cannot be a PhD. And in some states, more than one state agency may be involved. All interested parties must be notified. Again, this is back to the issue of one parent can't secure guardianship without appropriate notifications, etc. Court appoints someone to represent the individual. That's the guardian ad litem. Some fee can be incurred as a result of the guardian ad litem. Guardian's powers in dealing with the person's property are carefully restricted by law. And this is where we get into the partial or limited guardianship versus full guardianship. Okay, liability of the guardian. I'm frequently asked by people, goodness, if I'm the guardian, does that mean I'm responsible for everything they do? And the answer is no, not legally at least. So a guardian must use reasonable care and caution when making decisions and doing things on behalf of the protected person. Unless a guardian acts negligently, unreasonably, or irresponsibly, a guardian is generally not personally liable for any of the actions taken on behalf of the protected person. So if the person holds up a bank, you're not an accomplice, this type of thing. The court, by way of your reporting initially after the first year and biannually afterwards, that's their way of making sure that you're in the individual's business, that you know what's going on, etc. As far as what guardianship does, it does take away some of their rights. However, they can still drive and they can still vote. So it's possible for you to have guardianship for them and for them to have a driver's license and for them to still vote. But they can't enter into contracts without your approval, meaning they could not finance a vehicle, take out a credit card, they could not get married. These types of things where they are legally binding themselves are not appropriate because, guardianship is in place and those responsibilities as a result of that court action have been transferred to the guardian. A guardian may be removed by the court if they are not properly performing their duties. And I've seen situations where an individual may get an advocate involved in this type of thing. So if one's going to be guardian, you want to execute your duties appropriately. A successor guardian would be appointed if a guardian were removed, and a successor guardian may also be appointed if the first guardian resigns or dies. By the way, successor guardians, these types of things can be appointed as a result of being joint guardians, meaning if you have a joint guardian situation and one guardian dies, the remaining guardian becomes the sole guardian. Guardians also can be appointed as a result of being in someone's will, where you have a will, in other words, in your estate plan, you have specified who you want to be the successor guardian, such as an adult sibling of your child with special needs, and this type of thing. Now, in situations where one is a joint guardian, they do not have to return to court to become the sole guardian. If someone is listed in a will, either for a minor child or an adult child for whom you have obtained guardianship, then listing in the will gives them preferential treatment. However, they would still have to go to court in order to obtain the court order, putting them in the place of guardianship. Termination, guardianship generally terminates when the protected person reaches age 18, and guardianship was established prior to age 18. So it's an appropriate time to pause and make sure that everyone on our meeting this evening understands that guardianship prior to 18 is an exceptional situation. So a biological parent or an adoptive parent typically does not have to go to court to obtain guardianship prior to the age of 18. And in fact, they're discouraged from doing so because they're already in charge. The exception to that would be where the individual is a minor and the parent lacks capacity due to an accident or injury, this type of thing, or where a parent has passed away and a guardian needs to be appointed. So there are some situations where guardianship is appropriate prior to 18. Another would be when the minor actually receives a settlement, a legal judgment, or inherits a large sum of money. Then it's very common for the parent, biological or adoptive parent, to go to court to obtain guardianship for the estate of a minor. Now, please understand, if guardianship is obtained prior to the age of 18, when they turn 18, the guardianship terminates. The reason for that is again, state law presumes at age 18, they can be in charge of their stuff and make their own decisions. So if there are special circumstances that necessitate going to court to obtain guardianship before age 18, great. Otherwise, if this is one of those where I'm going to have to get it at 18, so I might as well go to court and get it at 16, don't. You'll find yourself probably having to return to court, pay for an attorney again in order to get the guardianship transferred from a minor situation into an adult situation, because it's different. As a minor, you're not taking away their rights. They did not have them in the first place. And so just as with SSI, getting SSI for a minor with special needs or a disability is different than for an adult. Same thing with guardianship. Just with a minor with SSI, you have to revisit the qualification to transfer it to an adult situation. Same thing with guardianship. You're back in court having to transfer it from a minor or juvenile guardianship situation into an adult. So again, reasons for terminating guardianship. The protected person is no longer incapacitated, unusual, but could happen. The protected person dies, it's unfortunate. In the case of a guardian of the property, the estate is exhausted, meaning there's nothing to be guardianship over anymore. Or the protected person moves out of state. Okay, so a variety of reasons why guardianship is no longer active, needs to be terminated or changed or transferred. So let's talk briefly about alternatives to guardianship. So guardianship is most often appropriate when the person lacks capacity. That is, they're unable to handle their affairs, their financial affairs, unable to pay bills, balance a checkbook, handle money, make change, and deal with financial issues. Another example would be when they're unable to take care of their health care or make health care decisions. So when they struggle to take care of daily issues, this type of thing, guardianship may be indicated. When they're actually doing a decent job of those things, and the concern is less dealing with things every day, but more concerned with dealing with things should they have a situation such as an illness or an accident or something that would cause them to lose capacity or lose their ability to handle affairs, then like you or I, it's wise to have a series of documents in place so that you or your significant other or parents or whoever's appropriate can actually step up and assist them, and that individual is actually designated. So you're not relying upon, well, I'm the parent, so obviously I would do that. It's not so obvious anymore. So if you don't have guardianship as a result of feeling that it's more than what's necessary, then that would reflect on whether your child or dependent has capacity. And if they do, then you may want to work with an attorney and assist them in entering into a healthcare representative document where they specify you or whomever to take care of their healthcare decisions in the event they are incapacitated. The same thing with their business affairs, called a durable power of attorney or durable POA, specific POA, trust, and so forth. So they can make these elections prior to an event occurring. And if you have the document in hand and they can't speak, or because of accident, illness, or something, they are unable to handle their own affairs, then that paper or that a document will enable you to step up and act in their stead. So we have the most common documents are the healthcare representative and the durable power of attorney. Representative payee at the top, of course, reflects who is receiving or in charge of their monthly Social Security payment. And those payments can be small, relatively small. I see SSI maybe for $200 or as much as $800 per month. And then there's Social Security disability or SSD benefits, and those benefits can be more substantial. So those benefits range anywhere from also a few $100s clear up to $1,900 per month. And so being the representative payee means you're in charge of that. You are, of course, obligated to use those funds on behalf of the individual they're being paid to. But so having a representative payee is another way to have somebody helping manage your affairs. Executing your healthcare representative and your durable power of attorney, specifying who's to take care of those things if you can't, another example. Having a trust, and next week, first opportunity this evening to put a plug in for next week's workshop, which is all about special needs trusts, and having a trust and someone to serve as trustee, again, another way to get help in managing your affairs. And next week, we're going to drill deep on special needs trusts. You probably have never seen as thorough an explanation about special needs trusts as we're going to have next week. You may be a surprise to you, but there are actually about 5 different types of special needs trusts. And most people think I just need a special needs trust, but there's more to it than that. We will get into the thick of that next week with what's the difference between a first party and a third party, what's the difference between a revocable versus testamentary, what's an irrevocable special needs trust, and why would I want to consider that? What are the tax implications of these different types of special needs trusts? Do you pay more in taxes with one than another? And whose tax liability is it? Is it the disabled person? Is it the parents? Is it someone else's tax liability? And when do you have to file a tax return for a trust or this type of thing? We'll get into Miller trusts and what they are. We will also get into trustee issues and if money just sits there earning nothing, or can it be invested, and what are the implications of that, and so forth. So special needs trusts like you have never seen it before next week. And I would encourage you not only for you to participate, but please invite your friends. You can't Google this stuff. It would take forever to try to piece this stuff together just with a hunt and peck approach. And you'll get it all in under 90 minutes, and strongly would encourage you to participate. You, case managers, direct service providers, grandparents, because it's free. And this is the best opportunity available to drink in this valuable and helpful information. Okay, protective proceedings, that's where one's affairs are overlooked as a result of proceedings from the court. And then, of course, parental powers where appropriate. All right, so there are a number of alternatives. In the state of Indiana, as of about 3 years ago, we also added to this having supported decision-making, where a person elects to designate a person that can assist them in making decisions. So if you can kind of look at the palette of colors here with guardianship, you have full guardianship, that would be at one end or one extreme where you're guardian over everything. Then you would move from that to limited or partial guardianship over just the estate or the person. And then from there, it would move to supported decision-making, where they are power sharing with someone who helps them make decisions, this type of thing, and designating that person. And then from there, you would move to where they have capacity and they execute documents indicating who they would want to assist them or do things for them if or when something occurs that causes them to lack capacity. So, so there are a variety of options. It's not, it's not just one or the other. And so we help coach families on a daily basis about the different options and what they may want to consider, the costs involved, the implications, etc. Any questions? Okay. All right, we're right on time. We're doing great. Well, we are near the end of guardianship, and then we'll be moving to ABLE account, which is really exciting. I think you're going to enjoy that. The representative payee, of course, deals with the Social Security benefit, and there's some new updates on this because of how Social Security is functioning relative to COVID. So first of all, in terms of explanation, the person authorized by the Social Security office to receive and manage federal funds for a person who is unable to manage their own funds. So oftentimes Social Security starts when a minor turns age 18. We did discuss in government benefits last week that a person from birth can actually receive SSI if they have a disability and the family or household's finances enable them to be eligible.
Jerry and I never settled this because we just weren't sure.
Someone needs to mute, if you would be so kind. Again, someone needs.
But we weren't sure about this.
Please.
But
Okay.
so we were knowing that we were on the fence. Neither one.
Someone doesn't know we're hearing them. Please mute. Thank you. All right. So
you're talking about guardianship now. The second half is ABLE accounts, and I'm not really sure what that is.
Okay. So ABLE accounts we'll get to in a moment, and to help that person, bless their hearts, ABLE account stands for Achieving a Better Life Experience, and it's actually a savings and or investment account that a person with a disability can have without losing their benefits. So if you've not heard about ABLE accounts, stay tuned because it's new and pretty exciting, because an individual with special needs that has SSI, like mentioned here, and a representative payee, and even has a guardian and so forth, can have an investment account and keep all their benefits. And that is really exciting. So that's coming up here in about 5 minutes on ABLE accounts. Let's see. So the representative payee typically gets a letter indicating that the individual that they're assisting is receiving benefits. And you go to the bank, usually with the letter and the first check that often comes before the representative payee account is set up. So you go to the bank. And for those of you that have children that are, 3, 4, 5, 6, 8, 10, or 17, but they're not 18 or 19, or you have not embraced SSI yet, this is very helpful. You take the letter and check, usually, and you go to the bank or credit union.
Grade, the entire bed.
Okay.
The alley, wall, by the fence.
Okay. We're still hearing you, whoever that is. You go to the bank and you ask them to set up a representative payee account. Usually they want to see the letter. They want to know that Social Security has been approved. This is not a moneymaker for the bank or credit union. So usually they are reticent to set up the account unless they know for sure the Social Security has been approved. So you set up the account. Usually the name of the individual that qualifies for the benefit is on the account, the parent's on the account as well. The child's name is on there for Social Security to put money in the account. The parent's name is on there to be able to transfer money out of the account.
Do you have a guardianship over here?
Okay.
No. Okay, so he does financial stuff and everything.
Hello, I'm sorry, but I can't hear you because the other lady that's talking.
Yep.
Yeah, it looks like it's someone by the name of Sherry.
Yeah, I can't hear. Yeah, I can't hear either.
Sorry, okay, Sherry, we are thrilled you're joining us, but if there's any way you could click mute, please, Sherry, if you could click mute.
Different things, but next week is trust.
Okay, thank you, Sherry. If you could click mute, please. Thank you. Okay. All right, so the representative payee is the person that is handling the funds. And if, as an example, the individual receiving the benefit is living with the representative payee, usually the representative payee is transferring money out of the representative payee account each month, and it's being transferred to the individual that is assisting with the expenses, et cetera. So there we go. And I think we've got, I think we've got things taken care of on the mute front. So this is good. We're doing awesome. Thank you. Okay, healthcare representative. That's where if one has capacity, they can sign a document, typically drafted by an attorney, and that document then provides specifically who is to make healthcare decisions for them. In the event they become incapacitated, cannot make decisions for themselves. This can be a parent, can even be a friend, does not have to be a relative. But this document is very helpful for two reasons. Number one, medical care providers will be asking, do they have a healthcare representative? Who can we listen to? And then number two, it avoids confusion where multiple people are trying to control the situation or make decisions for the individual. Durable power of attorney is all the business stuff. Who takes over the checking account? Who pays the bills? Make sure that things don't go into default, etc. Durable power of attorney is a very powerful document. An example with this is when my dad went to hospice through a durable power of attorney, I was able to assume responsibility for his checking account, pay for his final expenses, arrange everything, etc., for his impending death. This is an example. One doesn't have to be dying necessarily, but again, this is designed so that business affairs can be maintained as you move forward, and with hopes, of course, that the person will return to having capacity. The healthcare representative and durable power of attorney are not expensive. They are very inexpensive to execute, and certainly less expensive than guardianship, but the attorney that you work with is going to want to make sure that the individual signing it understands the document, meaning has the capacity to understand the document that they're signing. So if one cannot sign, cannot understand the type of things that we're talking about, these are indicators that either guardianship, partial or total, or supported decision-making may be a better route to go versus these other options. Specific power of attorney, we've all seen situations where somebody signs a temporary power so that a spouse can handle someone's signatures at closing or emergency guardianship situations, etc. So these are kind of narrowly defined and specific in their scope. As far as a trust is concerned, again, another plug for next week, and we're going to drill deep into trusts and special needs trusts and so forth. But special needs trusts are one of the greatest gifts we as a special needs community are ever going to receive, because it gives us a safe haven where inheritances, life insurance proceeds, monies left over from retirement accounts, property, a condo, a house, etc., can be placed in safekeeping for the individual with special needs. As a result of having a trustee in place, we make sure property taxes are paid, that roofs are taken care of, the yards are mowed, and in other words, that things are taken care of for them as appropriate. So powerful, so amazing. And we will talk about the different types of special needs trusts next week. It may be a surprise to some of you, but it's possible for there to be thousands of dollars in a special needs trust, tens of thousands, hundreds of thousands, while an individual has Medicare, Medicaid waiver services, SSI, supported living, subsidized housing, Section 8, food stamps, and I could go on and on, despite the fact that there are thousands of dollars sitting in a special needs trust. So as you'll find out next week, the way this works is you want the government to do as much heavy lifting as possible, and you want the trust or what's in the trust to take care of everything else. So for many individuals with special needs, again, the government is the food and shelter and healthcare. The trust is the everything else. And that everything else is, oh, you name it. I mean, what things do you enjoy? Most of us do not enjoy food, shelter, and healthcare. Most of us enjoy sporting events and concerts and travel when we can, and going to Disney World or taking a cruise or going to Florida in the winter. And I mean, the list goes on, having a cell phone or having Netflix or television or a flat screen TV, going to the zoo or going to the children's museum, horseback riding, going to the lake, going fishing. I mean, all kinds of things that we love to fill our lives with that add value and meaning and give us things to look forward to. Well, individuals with special needs are no different. They want to look forward to these things, and the reality is that's not what the government provides for. So special needs trusts are by far the front line for how we can make provisions for our loved ones with special needs so that their quality of life does not go off the cliff when something happens to us. More on that next week. and protective proceedings. All right, parental power. If you're the parent, in most cases, you don't need to secure guardianship. We talked about that already. And we are at the end of guardianship, and we are roughly at the halfway point. Are there any questions anyone wants to pose on guardianship before we move on to ABLE this evening?
I had a quick question about guardianship in terms of a child under 18. We've established that in our will for a non-disabled child. Would we need to do anything different for a child with disabilities?
Okay, from the guardianship perspective, no. The only consideration is in selecting the who for the guardian. In some cases, parents, I don't know, think a little deeper or think a little further about not just whether they can parent a child, but specifically the child or dependent with special needs, meaning it sometimes affects the who, is what I'm saying. But making a provision in your will for who is to be guardian certainly would apply to the child with special needs as well as your other children. So the difference is when they turn 18 and making a determination about whether whether you'll want your ability to help manage and do things for them to extend beyond age 18. But basically, the answer to your question is your will is fine. Yes. Right. Now, there are 4 things that we will talk about throughout the series that favorite family member who will step up to be guardian is looking for, because sometimes family disappoints and they're a little hesitant to take on, the handling things for a child or dependent with special needs. We'll mention them again next week, but to run through them briefly, one is they want to know if something happens to you that the government benefits are not lost. That is Medicaid waiver services, Social Security, perhaps an IEP or 504, voc rehab services, et cetera, et cetera. They want to know that all the benefits you've worked so hard to get in place for your child or dependent are not going to be lost if something happens to you. And, as we discussed last week, if they inherit, they're toast. Most of these benefits are means tested. Medicaid is, Medicaid waiver services are, and certainly SSI. And if they're means tested, the threshold in Indiana is $2,000. So if they inherit and now they've got $5,000, they're no longer eligible. They're with their SSI, they're with Medicaid and so forth. So part of the planning process is to create an airtight situation so they simply do not directly inherit. Now, does that mean we want to cut them off and leave them nothing or leave them simply to what the government provides? Well, that's how things were decades ago. Absolutely not. What we want to do, as you'll find next week with Special Needs Trust, is we want to direct whatever their inheritance is, whatever their slice of the pie is, whatever portion of what you're able to leave for them is for their benefit. We want to direct that to a properly established Special Needs Trust. And that protects their continued eligibility for benefits. But that's number 2. First is keeping the government benefits. Number 1, but keeping the benefits. Number 2 is a Special Needs Trust to pay for what the government can't or won't. The third thing is that there's a team. Typically, family members do not want to be a team of one. They want to know that there's case managers, there's people at school, there's people in the medical community, there's case management, there's a team. They're on a team. A team is good. And then fourth is they want to know that the letter of intent, which is the caregiver guide. So they want a manual, an owner's manual. So between the owner's manual, there's a team, government benefits, and a funded trust. It's amazing. We rarely have trouble getting family to sign on, step up, et cetera, when we have something so well planned out, so well thought out. It removes or at least reduces substantially their anxieties about their willingness to serve. So I hope that's helpful. Okay, we are going to move from guardianship now to ABLE, because I don't want to run out of time, because we have got great stuff on ABLE accounts. Okay, so we're going to go back to screen share. Let's see here. Okay, and let me get, Okay, yep, close out the guardianship. Thank you for your patience. Okay. Okay, and we should have Abel. There we are. Okay, and if someone would be so kind to give me the thumbs up that we're good with the PowerPoint. No, we're not. Thank you. Thank you for letting me know. I appreciate that. Let me drop down. Let me find the share screen. There we go. Boom. And boom. And boom. And boom. And all right. Thank you. We are a team. I love it. Okay. All right. So the ABLE Act, and this is great information. I think it'll be a more thorough covering of ABLE than you've seen before. But the history of this is recent. So the ABLE Act renamed the Stephen Beck Jr. Act because this is a gentleman from Virginia that spent the last 7 years of his life championing the cause of the ABLE accounts for his daughter with disabilities. And he literally did pass. You can Google him, Stephen Beck Jr., and he passed on the eve of Congress passing the legislation that brought about ABLE. So you might say he gave his life to this. And I spoke at a national ARC conference a few years ago and got to meet his wife, and it was so cool. And at that very conference, I was delivering an address on ABLE accounts. And she came up afterwards and she said, "Thank you for the great presentation. It meant a lot to me." And I said, "Thanks very much," not knowing who she was. And so she looked at me a little odd and she said, "You don't know who I am, do you?" And I said, "No." I said, "But please share with me." And she said, "I'm Mrs. Beck. My husband is the person that championed the cause for this." And you know, and it was just so cool. I got to tell you, it was one of those kind of goosebump moments. But at any rate, it came about at the end of 2014. So we kind of got rolling with this in 2015. And the legislation was patterned after the 529 college savings accounts that by that time had already become popular, like the college choice here in Indiana. So part of where this came from was parents putting money into 529 accounts for kids that they thought would be college bound, but maybe I've got a kid that's not college bound due to special needs. What can I put monies into for them? And what do I tell grandparents and this type of thing? So legislation has been passed in most states to create various state plans. So most states have their own ABLE accounts. And there is a national resource center called ablenrc.org, which is a clearinghouse of information on ABLE accounts. So you can visit that if you want to see what one state has versus another. In addition to the act that passed at the end of 2014, the legislation that passed the fall of 2017 brought about enhancements, and this was the Tax Cut and Jobs Act of 2017. So the ABLE that first passed at 2014 is not the ABLE of today. It has been enhanced. It's been helped. So eligibility requirements for an ABLE. So who can have one? If it's so good, then who gets one of these? And the answer is one must be blind or disabled at this time prior to age 26. So, so typically we're looking for a disability that originates prior to 26. There's no rhyme or reason as to where they came up with 26 from, except for the Affordable Health Care Act. Being to age 26, one can stay on their parents' health insurance. There's nowhere else 26 appears, but oh well, they borrowed it from that, we guess. And in some cases, if a diagnosis is prior to age 26 will result in disability or death, such as spina bifida, hemophilia, or muscular dystrophy, they can be eligible. So one does not have to be disabled prior to 26, but the origin of their disability must be before 26. And this we're looking to change. We're hoping there will be sponsorship or co-sponsorship of legislation to raise that age to potentially as much as 46. So stay tuned and we'll see if we can get further enhancements on ABLE, which is getting catching a lot of attention these days. But at least at this time prior to 26. So let me give you an example where someone would not be eligible. If an individual's disability occurred as a result of an auto accident at age 32. So prior to the auto accident, they were not disabled. The origin of their disability was the auto accident that occurred at age 32. They would not be eligible at this time for an ABLE account. So on the other hand, if someone was diagnosed with muscular dystrophy at 17, but they're now 28 and they're pursuing a PhD or an MBA or something in college, and being the most that they can be, likely they are eligible, even though they may not be considered disabled at this time. That's because the origin or diagnosis for the muscular dystrophy was early on, and most likely with muscular dystrophy, the diagnosis would have come much earlier than that. But anyway, I think you get the idea. If the age criteria is met and an individual is already receiving SSI, such as having applied for it at 18, this type of thing, and or SSDI, as you may remember from last week, a person with with a disability can draw off of their own wage base as early as age 22 or 23. So one could even be on SSDI before 26. Then it's a slam dunk, they're automatically eligible. If the age criteria is met, but the individual is not receiving SSI or SSDI, then a statement from a physician, or there's, in other words, other documentation that would win the day. Okay. All right. So, and by the way, we will talk about the different ABLE options in a moment, because Indiana has an option, Kentucky and Ohio have an option, and then there's a Virginia plan that is extremely popular, and we'll talk about why in a moment. So you have access to multiple plans, not just what Indiana has. Maximum annual contributions, $15,000 per year, and it's limited to the annual IRS gift tax exclusion amount. So that's been the same for several years, and that is $15,000 is the maximum amount that an individual can give to another individual without the need to file a gift tax return or to pay any taxes. So Enable adopted that. So they kind of borrowed, different elements from here and from there in putting this legislation together. But $15,000 is the annual maximum under normal circumstances, but there is a big exception, and we'll talk about that in just a moment. Big exception, big. Okay, so maximum account balance, $100,000 for someone receiving SSI. So earlier today, I was on a Zoom call with someone, and their child was 33, as I recall, and they were receiving so much in the way of SSI and so much in the way of SSDI. So because they are receiving SSI, their ABLE account needs to stay under 100,000. If an ABLE account reaches 100,000, their benefit's going to be suspended until which time they have spent money from the account and it drops back down under 100,000. Well, obviously, with an annual limit of 15,000, it would take a lot of effort to get to 100,000. So we've not seen that yet, but maybe somewhere down the road. There is also a Medicaid maximum for these ABLE accounts, and it's the same as the plan maximum for 529 college accounts, currently $450 in Indiana, $350 in Kentucky. And that limit is for maintaining Medicaid eligibility. So if someone doesn't have SSI, then technically they could go as high as $450,000 in the state of Indiana. But again, at $15,000 a year, it would take a long time to get there. If SSI recipient's ABLE account goes over 100,000, SSI is suspended. Their benefit is not canceled. It's simply suspended until which time they drop back down under the 100,000, about like exceeding the $2,000 resource limit with a checking or savings account. Your benefit is suspended. When you drop back down under 2,000, it can be restarted. Having an ABLE account right there does not affect Medicaid. So a person can have an ABLE account and for Medicaid purposes up to $450,000 in Indiana. So these are accounts with much higher ceiling than $2,000 and a great place to set aside funds for a variety of reasons. We'll look at examples in a moment. One ABLE account is allowed per person. Please keep that in mind. So unlike 529 college accounts, it's different. With that, each grandparent can set up their own 529 for their grandchildren. But with an ABLE account, it is actually the consumer's account. That is the account beneficiary or the individual with a disability, it's considered their account and there can only be a single account. So you can have 15 relatives want to get in on the act of helping out with contributing to the ABLE, no problem, but they better not be putting in more than 1,000 apiece, because 15,000 is the annual contribution limit, with one exception that we're going to get to on the next screen. Contributions, again, can be made by anyone. Any questions so far? Okay. And here comes the exception. So with enhancements made in 2017, tax and penalty-free rollovers of up to 15,000 from a 529 account can be made where the ABLE account holder or a family member of the account holder is the 529 beneficiary. So what does this mean? This means if a parent or parents had a 529 college account for their child with special needs, but they're not going to need it for college, they can elect, in order to expand the variety of things the funds can be spent on, they can elect to roll it over penalty-free and tax-free to an ABLE account. And as you'll see a couple of slides later, it can be spent on all kinds of things, certainly not limited to school or college. So that's one of the enhancements. Please keep in mind that that transfer, that rollover does count toward the annual contribution. So if you had $30,000 in a 529, it's going to take 2 years at $15,000 per year to get that transferred over to an ABLE account. Rollover of certain retirement fund accounts may be possible. An example would be if an individual with special needs changes jobs. Excuse me, they're making maybe $8 an hour and they take a job for $10 an hour. You know, fantastic. But, you know, while they were at that $8 an hour job, the employer was setting money aside in a 401k, which, by the way, happens often even when it's a part-time job. 401ks are more often than not available to employees that are part-time. So now while they were an active employee, that money in the 401k did not count as a resource. That's because you're active. You can't have it now. It's for retirement. However, once you terminate, then of course you can wipe out the 401k. You can transfer it to an IRA. You can just take the money. And so when our special needs child terminates, then now that retirement account becomes an available resource. Well, one of the enhancements was the potential, and this is all very new, I will add, but the potential to transfer the funds from the 401k into an ABLE account. I think what we're looking at there is paying taxes, but not being subject to a penalty. All right, credit for qualified retirement savings contribution may be possible if the individual is filing taxes. That is not being counted as a dependent by a parent and therefore not filing an income tax return. Last but not least is that exception that I was talking about a moment ago, and that is that account holders with earned income enjoy a higher contribution limit. So in addition to the 15,000 that's in place, they can contribute up to the lesser of their annual earned income, or $12,760. You saw it here. That means the potential exists if they literally were to earn $12,760 in a single year, they could put in $27,760. So again, the ceiling is much higher for someone that has earned income. Now, lest you think these ABLE accounts are the end all and who needs a special needs trust, and this is just amazing, we got to look at what works and what doesn't work with regards to an ABLE. Oh, by the way, beneficiary or legal guardian manages the account. So beneficiary, if there's no guardianship in place, they can manage their own account. They have capacity. If there is a legal guardian, back to our discussion earlier this evening, in place, the legal guardian would be the one in charge of the account. And here's the laundry list, not certainly the end all, but just a sampling of the different things that the ABLE account can spend money on. Education, housing, transportation, employment training and support, assistive technology and related services, health, prevention and wellness, financial management. If they need somebody a bookkeeper to pay their bills or write their checks, that type of thing, the ABLE account can pay for that. Legal fees. If they don't have a special needs trust and a parent's like, I need to get a special needs trust for my son or my daughter that has Down syndrome or has special needs, But how am I going to pay for it? Well, money in an ABLE account could pay the attorney's fee to set up the special needs trust. Final expenses, basic living expenses, and so forth and so on. So lots of things that ABLE monies can pay for. Okay, one thing to keep in mind with ABLE is that because the consumer's money is welcome in ABLE, meaning the individual with special needs or a disability can in essence stow away or hide their own money in an ABLE account to qualify for benefits. Because of that, their ability to do that, there is a Medicaid payback. So currently, per Amy Corbin, the state director for ABLE, the state of Indiana is not enforcing the Medicaid lien on ABLE accounts. That may change in the future, but at least for now, that's a wonderful thing that they're not doing that. But again, these ABLE accounts may, you may have it for 10 years. So I don't know what the future holds, but the state does have the ability to decide they're going to impose the Medicaid lien on the account. So what does that mean? That means upon the death of the account holder, the state reserves the right to reimburse themselves for Medicaid benefits afforded the account holder from the time the ABLE account was set up, not from birth, but just from the time the ABLE account was set up. So if from the time the ABLE account was set up to the time of their passing, Medicaid delivered $100,000 worth of services, then technically the state could seek as much as $100,000 of any remaining balance in the ABLE account to reimburse them for services provided. Again, as I indicated, at least for right now, the state's not imposing, but we could be talking decades down the road, so it's difficult to know. Okay, most states have adopted, so most states have a plan. There are a few that don't, and most of those states have tagged on to a neighboring plan, meaning they've decided instead of having our own plan, we'll use the Ohio plan, or we'll use the Indiana plan, or this type of thing. But most states have their own plan. Okay, let's see here. The ABLE Act requires that any state that establishes a plan must provide adequate safeguards to prevent excess contributions. That's one of the reasons for each individual only being able to have a single plan. Individuals can enroll in any state's ABLE plan if the program accepts out-of-state residents. Most do, but there are a few that don't. And that has changed in the last 6 years. So there are a few states that didn't, but they do now. But you'll want to make sure before you, as a part of making your decision, if you want to go to some other state's plan, like let's say you want to go to a state's plan that uses Vanguard funds because you just love Vanguard funds, make sure that they accept out-of-state residents. For the moment, and again, we're also working on the state of Indiana, but at the moment, there are not special tax advantages specific to the state of Indiana, like there is with the 529s. So some of you may be aware that with the 529, you get a state tax credit equal to 20% of each annual contribution, subject to a ceiling of $5,000 worth of contributions. That's with a college account. No such thing exists with ABLE at this point. The COVID has slowed down the efforts to amend things at the state level, but we'll see what the remainder of this year and next year brings. Okay, Kentucky has an account called Stable. We kind of chuckle with that because you think Kentucky had something to do with horses. It seems as of late, horses that got a little extra help, shall we say, and we'll kind of leave it there. Oh boy. But nevertheless, Kentucky has Stable. Also, Ohio has Stable, the Stable account. Indiana, Invest Able, run it together, Investable, kind of catchy. And then Virginia has Able America. Well, the Virginia plan is growing very fast, and that's because the Virginia Able America plan uses American funds, which are extremely popular. And the Virginia Able America plan can be set up by an advisor for a family or a consumer. Otherwise, like Invest Able or Kentucky Stable, these types of things, you go online and it's self-help, meaning you set it up yourself. With the Virginia plan, which is available all across the country, including here in Indiana, an advisor such as myself actually sets it up for you and provides personal service associated with it. Okay. Opening an ABLE account. The state determines the enrollment process. Enrollment and maintenance of the account is primarily done through the individual state ABLE program, website or online portal. Some allow via mail or fax, but for the most part, to set up an account other than the ABLE America account. So if you're doing Invest ABLE for Indiana, you would go online, find the website, and set it up yourself. The ABLE America, the Virginia plan, is set up and serviced by an advisor. Depending upon the state, there may be a minimum contribution to open the account and an annual maintenance fee to keep the account going. So an ABLE account does not work well when you have $50 to open it and then you're going to add $50 a year, because the fees will basically eat up what you're putting into the account. So you want to have a little more critical mass than that to make ABLE work. And some programs offer prepaid or debit cards, and Invest ABLE here in Indiana does have an ABLE card, meaning you would have access to funds in your ABLE account through the debit card associated with it. Any questions about ABLE so far? This is the website for the National Resource Center. It's a national clearinghouse. It's not unique to Indiana. So this would have information on a wide variety of states. It can be a little overwhelming, but if you want to check it out, there you go.
Yeah, I've got a question. One of the examples of what you could spend money from an ABLE account on, you mentioned housing, which is also, what the SSI and SSDI partially go towards. So do I understand correctly that you could use the ABLE funds also towards housing and it won't affect the SSI, SSDI as long as you are below that $100,000 limit?
Okay, I think there were about 3 questions in there, so well done.
Sorry.
Not at all. Okay, so the first thing is yes, it can be used for housing. Literally, if you found a condo for $80,000, you could yank $80,000 out of your ABLE account and plop it down and buy the condo. Now, keep in mind that if someone has adult guardianship over them, it's probably their trust that should be buying the condo and not them relative to entering into contracts, including purchase agreements. But that's one example. In addition to that, the ABLE account could pay for an addition or could pay for, like an extra room or something like that. As far as ongoing expenses such as monthly rent, et cetera, yes, it can assist with added expense to enhance the quality of life. As far as affecting benefits are concerned, one would simply want to make sure that the way that they handle it is not looked at by Social Security as receiving what's called in-kind support and maintenance, or ISM as they refer to it. If one is on SSI, having ISM or in-kind support and maintenance can result in a reduction in your benefit amount. But if it's one's own money that's coming out of the ABLE, I think perhaps an argument can be made that it's not receiving in-kind support and maintenance if in essence it's their own money. But great question, and I guess take it a step at a time would be the answer. An ABLE account may not be the best vehicle if. So now we're going to kind of look at where maybe ABLE doesn't work so well, because we've built it up as this shining star and it solves all, but maybe not quite. So the first example would be inheritances, settlements, judgments, or contributions from family or beneficiaries that exceed the maximum annual contribution limit. So an example here would be a great uncle, let's say a great uncle dies and he left $100,000 to be divided up among his 4 great nieces and nephews. So now you have $25,000 coming to your child with special needs, and that would exceed the $15,000 contribution limit for ABLE accounts. So there are some limitations with ABLE. It doesn't cater itself well toward large sums of money. In addition to that, please keep in mind that ABLEs receive cash. ABLEs are not going to manage rental property, a farming operation. An ABLE account is not going to handle an automobile and the need for auto insurance and this type of thing. So ABLE accounts are set up for cash. And so that's what they receive. And so anything other than cash is going to need to look into a trust situation to hold those things. So it's limited in terms of amount that it can receive in the way of contributions, and it's limited in terms of the type of property it can have. contributions are not coming from the individual with a disability, and therefore it could go to a third-party special needs trust, avoiding the Medicaid payback associated with an ABLE account. So if we're talking about a mom, a dad, a grandmother, a grandfather, a grandparent, great aunts and uncles, and anyone that is other than the consumer with special needs, in most situations, it would be advisable if they want to make a gift or if they want to incorporate the family member with special needs into their estate plan, to not do it in the form of an ABLE, because they would be potentially taking monies that would not have to be subject to a Medicaid lien and subjecting it to the lien as a result of placing it into an ABLE type of account. In addition to that, we of course have eligibility issues because of the age 26. Until they work on that, the beneficiary cannot make financial decisions. So if there's no guardianship in place, and so the guardian can't set up the account because there is no guardian, and the individual struggles to make financial decisions, it may not be the best idea to put them in charge of an ABLE account. Okay, and last but certainly not least, a person can have both. They can have both a trust and an ABLE account, but ABLE accounts are ideal for these kind of situations. So let's look at these. Better suited for small settlements, unexpected inheritances, and other smaller amounts, or savings of the consumer. So let me give you an example. Let's say we sit down with a family and they're pursuing a Medicaid waiver for their 24-year-old. And that 24-year-old has $10,000 in a savings account. They're not on SSI. Well, we would need to get an application going for SSI so that then they could apply at the BEADS office, the Bureau of Developmental Disability Services, for the waiver. But SSI is going to turn them down hands down because that $10,000 in a savings account exceeds the $2,000 available resource limit. Well, throw the $10,000 into an ABLE account. They can immediately, without delay, claim poverty, make their application for SSI, and get over to the BEADS office to apply for the waiver. Does everybody see what I'm saying? So it is a quick and easy way to deal with resource issues to become eligible and or maintain eligibility for government benefits when the monies belong to the consumer, that is the individual with special needs, and we need to offload that. Frequently, your only alternative is to spend it. Well, sometimes parents don't get excited about prepaying the final expenses. And while they want their kid to be well clothed, $10,000 clothing spending spree, seriously? So I think you see what I mean. Sometimes it's just difficult to get rid of money that quickly when you're wanting to get the approval process going right away. So let's look at 3 examples here quickly, and let me keep my eye on the clock. But example 1, grandparent dies, leaves $10,000 directly to each grandchild. For the grandchild with special needs, it must be spent, used to prepay the final expenses, or deposited into an ABLE account. If the $10,000 goes into an ABLE, call it a day, and the $10,000 is no longer a problem. The only thing that you have to worry about is to work with the executor who's going to be making the distribution to make sure they don't make the distribution at the end of the month, but make it earlier in the month where there's time to get it into an ABLE account before it bleeds into the next calendar month. It's considered income in the month received. It becomes a resource problem when it bleeds into the next calendar month. Example 2, and these are real life examples, by the way, in case you're curious. Example 1, the grandparents lived in Cincinnati. So our grandparent lived in Cincinnati. These are real cases. The family was from Zionsville with a $10,000 problem. Example 2, school bus situation. Again, a real life situation, non-ambulatory, young individual with special needs. The wheelchair was not anchored. It literally rolled out the back of the special needs bus, and the child face planted on the asphalt. I mean, tragic. So needless to say, the school was interested in trying to settle the untidy situation. A $15,000 payment was made, but it was going to cause the child to lose their waiver because it exceeded the $2,000. And this is not money for the parent, it's for the child. So the $15,000 was swept into an ABLE account, benefits were retained, and now those funds are growing on a tax advantage basis to meet some future need of the child. Example 3, an individual with special needs gets a job. That's a happy dance, resulting in earned income. They want to save some of it for a vacation or furniture, additional schooling, vehicle, etc., while maintaining their SSI, Medicaid, and Medicaid waiver. An ABLE account allows for funds to accumulate for future use without being subject to the $2,000 resource limit. So those are just 3 quick examples where ABLE comes to the rescue. All right, ABLE accounts, things to consider with ABLE. ABLE accounts with limitations can address resource issues. Again, resource issues by keeping the inheritance, legal settlement, paycheck 529, savings and savings or investment account in an ABLE, the consumer is back under the $2,000 resource limit, and they're good to go. However, please keep in mind, ABLE will not fix income issues. Resource issues, yes. Income issues, no. Let's look at 2 examples. A consumer age 22 is receiving SSI and has a part-time job earning $500 a month. Placing his or her $500 paycheck in an ABLE account will not allow him or her to avoid the reduction in SSI because of the earned income. So 500 less the 85 that's waived, we talked about that at the last session, equals 415. And then for every $2 at that point earned, 50-cent, $1 reduction, in SSI. So half of the 415 is 207.50. So the ABLE account will not enable the person to avoid that SSI reduction. However, of course, it would assist them in keeping their resources under $2,000 to maintain benefit eligibility. Example 2, consumer age 35 is receiving $500 a month in SSDI from their own record of employment. More and more kids at younger ages are qualifying for Social Security disability off of their own part-time employment. It's really exciting. They also receive adult child benefits of $1,000 from a parent's record. That is a parent that perhaps is retired. They continue to work, earning $900 a month. They can save up to $25,800 a year. Remember the earned income plus the 15. So $900 a month is $10,800 on the year. When added to $15,000, they can put a lot into ABLE, bottom line. That keeps them under the $2,000 certainly. However, as their total income is $2,400 per month, that is $900 plus, let's see here, $900 in earned income, plus they're getting $1,500 in Social Security. So at $2,400, they're exceeding the $2,382 max for disability Medicaid. So in this case, we would need to set up what's called a D4B Miller Trust, where the monthly income in excess of $2,382 could be placed to maintain their disability Medicaid eligibility and therefore their waiver. So, so this is, and we're going to talk about Miller Trust next week, but I couldn't help myself putting a teaser in there about ABLE, or excuse me, about how Miller Trust can help deal with income issues. So, okay. Special Needs Trust, that's about next week, and we are almost at 8 o'clock. So all about Special Needs Trust, please invite your friends. We're going to talk, like I said, first party, third party, testamentary, standalone, irrevocable, revocable. Oh my gosh, it's going to be amazing. You're going to really enjoy Special Needs Trust next week. Of course, Mass Mutual, along with Down Syndrome Indiana, is sponsoring this series with our Special Care Division. We're very thankful. Let's see here. Okay, and this should have shown. And let me, there we go. Okay, let me go back, share, bring it up. Okay, are you able to see that? Yes, no? Okay, so thank you. So this is my contact information with regards to taking advantage of the free follow-up consultation. It's as easy as making a phone call or sending an email or responding to one of the pre or post workshop emails that you receive. Okay. All right. Well, any questions? I'm willing to stay on for another couple of minutes. We're almost at 8, but not quite. Any questions that anyone has at this point about guardianship or about ABLE?
Yes, I have a question. How do you report what you're spending the money on for an ABLE account?
Okay, so you basically don't. There are guidelines with regards to what the money can be spent on, but it doesn't get reported to court or Social Security, that type of thing. However, you have to stay within the guidelines on what you spend it on for the ABLE account to remain active and tax-free and not cause a problem with benefits. So I think the incentive is to follow the guidelines so that you do not create trouble for yourself. There's nothing certainly to keep Social Security from asking questions in a random audit situation,
Okay.
but there's not a routine reporting.
Okay, thank you.
Certainly. Other questions?
As long as you stay under 15,000 a year, you're okay, right?
Um,
For the able.
yes. Well, you can only have a single ABLE, and they would not allow you to contribute more than 15,000 unless you could prove that there's earned income to justify it. Great question. Thank you so much. With special needs trust, there is no ceiling, and we'll be talking about those next week. Other questions this evening?
I just have one more thing about the guardianship. The guardianship, once you have full guardianship, you don't have to reapply like every 2 years to make sure it's active, right?
You are correct. You do not have to reapply. You do not have to go back to court. The guardian, however, depending upon the county, and I appreciate your mentioning this because not all counties are enforcing this. You'll want to check with your respective county. Some counties want the biannual report, some do not. If you are in an account such as Marion County, and there are some of the contiguous counties around Marion that do, then you would submit that report on the first anniversary of the court order and each 2 years thereafter, but it is county specific and it may or may not apply in your situation.
Well, how would you know? Would they send you something saying they need this?
Not necessarily. My suggestion would be to check with family court in your respective county.
Okay,
Other questions?
thank you.
Oh, you're welcome. What a great group this evening. And I just am enjoying my time with you all so much. I so appreciate your participating and also the questions that you're asking. I look forward to meeting with many of you in the free follow-up consultation. Don't forget, same place a week from tonight on Special Needs Trust. You're going to love it. Again, I want to thank you for participating this evening. And at this point, I'll stop the recording and stop the sharing. Here we go. And
I do.